Good morning, everybody. Thank you for joining us this morning for the January 2020 installment of Bracewell's Environmental Essentials for In-House Counsel webinar series. As many of you know, we do these monthly as a quick update on timely issues in environmental law. I'm Ann Navaro, and I'm here today with Christine Wyman to discuss one of my favorite topics, the National Environmental Policy Act. We are going to cover this topic in the next 30 minutes. We do have the ability to take questions. So if you have questions as we go through this, please type them into the comment box on your screen. We'll get to as many questions as we can at the end of the webinar, and if we run out of time, we're happy to respond to those questions in a follow-up email. Next, you have our disclaimer slide, which you can all read at your leisure. So what we are really here to talk about today is the National Environmental Policy Act's birthday, as well as the birthday present that the administration has given to it. So the National Environmental Policy Act was signed into law just about 50 years ago on January 1st, 1970. And the regulations implementing that act were promulgated by the White House Council on Environmental Quality in 1978. It has been called the Magna Carta of environmental laws and covers a broad swath of federal activities, including many actions affecting private activities, because it governs how federal agencies make decisions on things like permit applications. So for its birthday, the administration has given the National Environmental Policy Act the first comprehensive revision of those 1978 regulations. And it is a substantial revision, as we will discuss.
Thanks, Ann. So last Thursday, the White House Council on Environmental Quality released its proposed revisions to the implementing regulations for the National Environmental Policy Act, NEPA. They then published those proposed revisions in the Federal Register on Friday. Normally, regulations of this significance take a few days to be published, or even sometimes a few weeks to be published in the Federal Register. The fact that it was published within a day of the announcement gives some idea of how quickly the administration wants to turn around these final regulations. So publishing the regulations in the Federal Register kicked off our 60-day public comment period. We will likely see some extension requests from those seeking to delay the rule, trying to get the comment period longer, so it'll be that much longer that the administration would be able to finalize those regulations. During the comment period, we're going to see two public hearings next month, one in Denver and one here in Washington, D.C. These will be an opportunity to hear previews of potential challenges from those wishing to oppose the rule. So before we start with the proposed revisions, just a quick primer on NEPA statutory basics. The statute is pretty broad and lofty, but does have a few specific requirements, namely as they relate to major federal actions significantly affecting the environment. And what that requires is for agencies to provide a detailed statement of the environmental impact of the proposed action, adverse effects, and alternatives. What NEPA is intended to do is really inform agency decisions on the potential environmental impacts of their decisions, and inform the public on the information that is considered by those agencies. It does not require any particular decision or outcome. And because the statute really is broad and lofty, much of the regulations that have currently been implementing NEPA really were at the discretion of CEQ in interpreting some ambiguous statutes. So it does seem like CEQ does have a lot of room to play with how they are going to revise those regulations, so long as they justify those.
So turning back to what CEQ has proposed with the draft rule, CEQ has explained in its rollout that its emphasis is on modernizing the regulations as well as making them more efficient in order to speed federal projects and federal approvals related to private action. They give as an example a variety of instances where environmental impact statements have averaged over 7 years, some even longer. Of course, many are on the shorter side as well. They also explain in the preamble that they've conducted a pretty comprehensive review of the history of how NEPA has been implemented, and that it kind of presents a confusing landscape. There are currently 30 guidance documents that the Council on Environmental Quality has issued over the years. There are many, many court decisions, as I'm sure you all are aware. They say that there are about 140 federal court decisions per year since NEPA was enacted, not including the 17 that have made it to the Supreme Court. And they also describe all the various agency policies and implementing guidance that have further changed the landscape. So that's the foundation upon which they base their proposal. And as I explained, if they finalize it in this fashion, it would certainly be a comprehensive rewrite. I would say that the proposed rule has about 3 buckets of proposed changes. One bucket is provisions that would codify existing legal principles or agency policies, but that are not actually reflected in the CEQ NEPA regs, and that sometimes provides grounds for confusion in the agencies or conflict in litigation. Just as an example, one of those things is private applicant involvement in the preparation of federal NEPA documents. That's not addressed in the current regulations, but it is a common practice in a number of federal agencies for them to allow the private applicant to pay an outside consultant to prepare a NEPA document for the agency as a way to get things moving faster and to supplement agencies' limited resources. That is not uncommon in the federal agencies, but again, not codified. And so they've proposed codifying that provision, the qualification being that the federal agency ultimately has to fully own that document and make sure it's fully accurate. I've seen that portrayed as a new thing in the press that further dilutes a federal agency's responsibility under NEPA. But in my assessment, in fact, that currently happens and is perfectly okay. It's just that they're going to codify it. The second bucket is a bunch of proposed changes that would streamline and modernize the regs. They've moved a lot of things around to make it clearer. They've deleted a lot of obsolete provisions. They've changed language that may be language that we don't use commonly anymore. So that's also a big bucket of changes. And then lastly, of course, is the bucket that contains some actual substantive changes to how the agencies do NEPA, and that will have a substantive influence on their analysis. Again, and we'll talk about some of those. But again, it's all aimed at trying to simplify and streamline the requirements and really focus the federal agencies on meaningful environmental issues rather than continuing what often happens currently, which is to take kind of a kitchen sink approach. One other overarching comment I would make is that the current NEPA regulations use a lot of what I would call kind of flowery and aspirational language in order to emphasize the very lofty goals of the statute. Some of that language sometimes is used, whether legitimately or not, to claim that agency documents need to be ever more perfect. This proposed revision takes out a lot of that language, I think, to try to go back to basics and really emphasize what NEPA was originally intended to do. So in terms of those really substantive changes, I'm sure you all have seen a lot of the press so far that hits some of these highlights, but I'm going to talk about a few of them. First is the way the proposed rule would redefine categories of environmental effects. So what sort of environmental effects does a federal agency have to look at when it's doing a NEPA analysis? As I'm sure everybody on the phone is very familiar with, for decades, we've had the formulation of direct, indirect, and cumulative effects. And so agencies have spent a lot of time not only identifying what are the effects of the agency action, but which bucket should those go in, direct, indirect, or cumulative. And the proposed rule, the preamble emphasizes that the administration believes that that focus on which bucket you put effects in detracts attention from really looking at meaningful issues and makes the process more complicated. So they've gotten rid of all of those categories. Now there's just one bucket that an agency has to look at, and it's what are the effects of its action. Perhaps most significantly, the proposed rule would delete any obligation to consider cumulative effects of agency action. That's obviously a very substantial change. As the preamble explains, the obligation to consider cumulative effects is one of the more challenging aspects of NEPA analysis for practitioners, lawyers, and everybody else who touches the analysis. So I expect to see that deletion as being one of the more controversial and heavily argued proposals. Another significant thing about the change to the effects definition is that the proposal makes clear that there's got to be really some actual connection, some substantial connection or reasonably close causal relationship between the federal agency and the effect for an agency to have to consider it. So it's not enough that there's just a but-for link. There's got to be an actual close causal relationship. And this is an effort to codify some of the case law that has developed around this issue, especially the Supreme Court's public citizen case. It's also reflective of the way some agencies, for example, the Army Corps of Engineers, already look at this issue when they're assessing applications from private entities for permits. Also, something that's gotten a lot of attention is another element of the proposed definition of effects, which is that effects should not be considered significant if they are remote in time or the product of a lengthy causal chain. So I think one way to read that is that you may still have to consider effects that fall in that category, but they don't in and of themselves trigger an environmental impact statement, which is triggered by significant impacts. And, you know, as I'm sure you all have seen in some of the reporting, the notion seems to be that among the effects that this would relate to is climate change analysis, which is generally considered to be remote in time and the product of a lengthy causal chain. So you might still have to consider it, but it in and of itself would not trigger the need for an EIS. Back to Christine.
Thanks, Ann. So Ann just went through some of the substantive changes that the administration is suggesting for the NEPA regulations that would provide some more direction and limitations and efficiencies for the review of NEPA. One of the other ways that the administration is looking at streamlining and narrowing NEPA is on the applicability of NEPA. And here we see a few different ways that they are attempting to more closely and narrowly define those federal actions that do require NEPA, and specifically an EIS under NEPA. So one of the ways that they've done this is redefining the definition of major federal action. So I mentioned that the statute actually uses this language that NEPA applies and an EIS is required for major federal actions significantly affecting the environment. Under the original and current definition of major federal action, it links federal action that is, it links private activities that are potentially subject to control by federal agencies. This new definition has more specificity and requires a more concrete relationship between the private action and the federal action. So the new definition would exclude non-federal projects with minimal federal funding or minimal federal involvement where the agency cannot control the outcome of the project. So it still does have this link that the agency has to be able to control the outcome of the project. So even if you have pretty minimal involvement, if the agency does have the ability to, say, deny your permit, even if that permit is for a small portion of the non-federal project, it's likely that NEPA would still apply. But changing it from, potentially subject to federal agency control to this more narrow definition will likely exclude some non-federal projects from the applicability of NEPA. It also eliminates from the definition of major federal action non-discretionary duties of federal agencies. So many federal agencies in their actions are operating under a statute that they have no discretion to act or not. And now this has codified the fact that where an agency has no discretion in their action, NEPA will not, that action is not a major federal action. And then finally, it also states that for an action to be a major federal action, it must result in final agency action that would be subject to challenge under the Administrative Procedure Act. Another way that the proposal would narrow the applicability of NEPA is by adding a whole new section on the threshold applicability analysis for agency consideration of whether NEPA applies. This seems to be a threshold analysis that the agency would undertake in advance of their scoping for NEPA to evaluate whether or not NEPA should even be a consideration as in their decision on acting on this on a non-federal project. So here, things that the agency would be considering is whether or not having NEPA apply would be in conflict with the statutory authority that the agency is acting under. Another new one that is included, though, has a little bit more subjectivity, and that's whether or not congressional intent would be conflicted with NEPA applying. And here, that might provide the agency a little bit more discretion as to whether or not the congressional intent was for a statute like NEPA to apply for the agency action. And then also whether or not the action is a major federal action. And then finally, one of the other ways that the applicability of NEPA could be changed is under categorical exclusions. So the proposed regulations have new regulations for agency codification of categorical exclusions. And a couple ways they differ from the existing categorical exclusion requirements is in the past, the categorical exclusion agencies could include these types of projects that did not have significant impacts, but it had to be almost like, except for extraordinary circumstances, the project would not have significant impacts. Now, under the definition of categorical exclusions, it's that the action normally would not have significant impacts. And there you see a little bit more discretion for the agency being able to include some projects that generally would not have significant impacts, but recognizing that there could be some extraordinary circumstances where there would be significant impacts. In addition, the regulations add a requirement that if there are extraordinary circumstances exist for a project that normally would be subject to a categorical exclusion, but that and those significant impacts would require an EIS, then the agency is supposed to evaluate whether or not those impacts can be mitigated so that you no longer have to prepare an EIS. This is in contrast to the current regulations that simply make the affirmative statement that there could be situations where there are extraordinary circumstances, and in those instances, the agency does need to prepare an EIS. So you see there's a little bit of a shift in the dynamic for the agency actually looking for opportunities to that the regulations are telling agencies to look for opportunities where NEPA actually would not be applicable.
Thanks, Christine. Just a couple of comments on the concepts that Christine went over. One of the things this proposed rule does is open up an argument that was settled a long time ago about the meaning of the words major and significant in the NEPA statute. As you all know, the statute requires the preparation of an EIS on a proposed major federal action significantly affecting the quality of the human environment. After initial argument over whether major and significant meant different things, CEQ settled that decades ago by saying they don't have separate meanings and they basically reinforce each other. But now the proposed rule would separate those words again, perhaps opening the question of whether some federal activities that are currently subject to NEPA are not major federal actions at all, and so don't require preparation of any sort of NEPA analysis. So it'll be interesting to watch how that legal argument plays out. The other thing I would say about the proposed definition of major federal action to exclude non-federal projects with minimal federal funding or involvement, I've seen the press characterize that as an out for projects like liquids pipelines that don't have overarching federal approval and that may just have small federal touches like a Clean Water Act permit from the Corps of Engineers. But I certainly don't read that way. The way I read that is underscoring the notion and the position that the government often takes now, which is that it doesn't have to federalize a liquids pipeline project for purposes of NEPA. It doesn't have to look at the whole thing, but still has to look at its little piece of it. So I don't see that definition changing that current practice, but rather supporting that current practice. The next thing I wanted to mention is the new definition of reasonable alternatives, just briefly. This is significant in that it brings notions of practicability back into the definition. Again, I think this definition reflects where a lot of federal agencies try to be with their alternatives analysis, but it's not necessarily always supported by the case law or the broad drafting of the current regulation. So the proposed regulation kind of brings us back to a rule of reason in that reasonable alternatives that an agency has to look at really have to be technically and economically feasible. They can't just be, kind of a wish list of things that an agency should look at. And they really, where we're dealing with private activity, they have to actually meet the goals of the applicant. And this is important because sometimes agencies go off on a tangent. For example, they're dealing with a permit related to a coal-fired power plant, and they decide they need to look at whether solar energy is a legitimate alternative. So this is important in terms of bringing the government back around to kind of a practicable approach that actually meets the goals of the project. And relatedly, the current rule requires that agencies sometimes look at alternatives outside of their statutory jurisdiction. The proposed rule would eliminate that requirement, again, bringing us back to a notion of practicability and the goals of the applicant. So obviously, we could talk all day about the proposed rule because it is such a comprehensive revision. Sadly, from my perspective, we don't have all day, but there are a few other items that I would highlight that you all may want to look at as you go through the proposed rule. Some of you all may be involved with trade associations that are commenting. Some of you all may be commenting, so this may give you some other things to think about. Part of the proposed revisions in Part 1500 of the rule address the nature of judicial review in what looks like an effort to kind of rein in some of the freewheeling, no-holds-barred type of litigation that we've seen over the decades. For example, the proposed rule would codify something that is a legal principle and that the Department of Justice often argues, which is that parties can't raise claims in court that were not raised in the agency to the agency in the public comment process. So if an outside stakeholder doesn't make a specific comment in the process and then tries to bring suit, this proposed rule would support the notion that they don't have standing to do that because they didn't participate when they were afforded the opportunity. Again, that codifies an existing principle, even though in practice it's not always applied by courts in the black and white way that this rule proposes. So this would support that. As I'm sure you all have heard, the proposed regulations also impose presumptive page and time limits for both environmental assessments and environmental impact statements. The numbers are here on the slide, even though actually they're not for EISs. So the proposed page limit for EISs is 300 pages, and then there are the proposed time limits. Interestingly to me, the regulations establish somewhat of a new role for a senior official at each federal agency. They designate the role of senior agency official as basically someone who has responsibility for keeping the NEPA process under control in each agency. So if you want an exemption from CEQ's page limit, if you want an exemption from CEQ's time limit, you need to go to the senior agency official at an assistant secretary level or higher, according to the proposed rule, to get that exemption. So again, that's a way of trying to streamline and control the process and kind of bring agencies back from always doing these very lengthy documents. Another interesting thing to highlight on this slide is what they've proposed to do with mitigation, which is in Part 1508. I think there's a sense amongst some that mitigation is sometimes used by the agencies in a way that it shouldn't be, that sometimes agencies seek mitigation from the private sector that goes beyond the real impacts of the project or beyond their legal authority. So even though NEPA doesn't impose any substantive obligations, it does clarify that, look, if you're looking at mitigation in the NEPA process, it has to have a nexus to the effects of the action. And agency, you have to explain the legal basis for your ability to require mitigation. And that could have implications for the way that the private sector tries to use mitigation to reduce impacts to smooth the permitting process along. So I think that's something interesting to keep an eye on. One other quick thing on this slide, Part 1506, CEQ has invited comment on whether an agency should allow some actions during the NEPA review. So right now, as you all are aware, during the NEPA review, if you're a private applicant, you can't do anything while an agency is thinking about your permit. You can't cut trees, you can't start a roadway, there's nothing you can do. So the question from CEQ is, are there circumstances where maybe some of that could be allowed without violating the statute? Back to Christine to sum up.
Great, thanks. So we have the proposal, comments are due in 60 days, but what comes next? The administration is attempting to finalize this before the election in November. This will likely be part of the campaign talking points for things that the Trump administration has accomplished in the first term. But one thing that will be of mind of the Trump administration is the potential Congressional Review Act effect. This is something that if the election were to go to the Democrats and the Senate were to flip to Democrats as well, it is a tool that Congress and the new administration could use to roll back this regulation if the administration does not finalize it early in 2020. Another thing that will likely be of their mind is the litigation associated with the final rule. If there is a change in the administration, that would mean that the next administration would be defending the rule, because there will no doubt be litigation over this. There might be some interesting defenses that this or any other administration would be able to employ trying to defend the rule regarding standing and whether or not the APA applies, but that will be left to be seen. Another thing that's of note is that in the proposal, the regulation actually says that there's a provision that for severability, so that parts of this regulation could go into effect even if other parts are enjoined or stayed by a court. So they are trying to move parts of it forward if others kind of fall down. This is, you could see, maybe applying to some of the more contentious and challenging aspects of the regulation, like the elimination of cumulative impacts. That's a section that might have more closer judicial review than some of the other sections, like page limits and things like that. Once it does go final, the administration will be looking at whether or not they need to update, withdraw, or repeal the existing guidance documents. Ann mentioned that there's 30-some guidance documents applying to NEPA currently, and so CEQ will be looking at how those might be impacted and what actions need to be taken, as well as what this means for their proposed greenhouse gas guidance document. The proposal recognizes that that is still pending and is taking comment on whether or not that should be finalized, if parts of that should be incorporated into the regulations, or what action the agency should take on that. And then finally, within 12 months of the CEQ implementing regulations being final, agencies need to start the process of proposing revisions to their implementing regulations. That will be whole separate rulemakings that need to be taken, and there will likely be litigation associated with all of those. So all in all, we're looking at the very beginning of a very long administrative and judicial process.
And look at that, we've taken just about 30 minutes. So I think we are set this morning, and we would be happy to follow up with any of you who would like to chat more. Thanks so much.